The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Good morning. Please be seated. Four cases will be submitted this morning. Those cases are State of Iowa versus John Senn Jr. Second case is Maryland Just and Others versus Farmers Automobile Insurance Association. The third case is in the matter of Joseph Sevick, Judicial Magistrate, and the final matter is Erica Spitz versus the Iowa District Court for Mitchell County. That last case is now submitted to the court without an argument. And before proceeding to arguments in the first case, let me just welcome the business law class from DMAC this morning. Thank you for being here. And Mrs. Mitchell, thank you for bringing the students. I understand you're going to stay through the second case, so the court will stay on the bench, but we'll have a brief recess to allow the students to leave. Okay, we'll now hear the arguments in the first case. Mr. Brown.
Good morning. May it please the court. My name is Brandon Brown, and I, along with Tammy Gentry, represent John Senn Jr., who, for the record, is present for his oral argument this morning. Back on September 1st of 2014, approximately 10 minutes after Mr. Senn was stopped for a traffic violation, he found himself being placed under arrest for operating while intoxicated. He was subsequently transported to the Des Moines Police Department, and he was then led to and placed in a closed room with the same arresting officer who had taken him into custody. At that point, he was read the implied consent advisory along with the Section 804.20 rights. And as this court knows, the results of his decision have consequences that not only bear on his driving privileges, but also may provide valuable evidence at his criminal trial in which he faces incarceration. Before making his decision, he elected to contact a lawyer. That contact occurred approximately 45 minutes after the time of stop. Approximately 2 minutes into his conversation with his lawyer, while still being in the presence of his arresting officer, he had requested attorney-client, which the officer correctly interpreted to mean he wanted a private attorney-client telephone call. At that point in the night, we are approximately 47 minutes post-traffic stop. The officer at that point tells Mr. Senn, no, you can't have a private telephone conversation. It only will be confidential if your lawyer comes down to the station. At that point, I would respectfully submit that Mr. Senn found himself facing a Hobson's choice. Either he could break his silence and make statements to his lawyer in the presence of an officer who was clearly listening to his conversation, or he could remain silent and forego the legal counsel he so desperately sought. And that brings us to the issue which we raised for argument purposes here today. We respectfully submit to the court that Article 1, Section 10 of the Iowa Constitution includes a specific, limited constitutional right for someone who is facing implied consent testing to have the right to speak with a lawyer telephonically and privately. And in order to support our argument, I would turn the court to the language of Article 1, Section 10, which includes in all criminal prosecutions and in cases involving the life, liberty of an individual, the accused shall have the assistance of counsel.
Well, okay, so, I mean, let's get to what I think is the key issue here. Under prevailing federal law, as I understand it, there might be some exceptions, but basically, the current federal standard at least, is you don't have a criminal proceeding, and perhaps not a case, until there's a formal charge filed. And I think it's undisputed that hadn't occurred yet. So, if I understand it right, you're asking us to depart from prevailing federal doctrine.
I'm asking this court to analyze my client's constitutional rights under the Iowa Constitution. As this court is well aware, it has the absolute ability to do that.
Sure. But the argument in favor of the federal strict, formal, gotta file piece of paper is that it's a bright line. And I think most observers would agree it is a bright line. And the critique of departing from that so-called bright line is that we'll be in a case-by-case quagmire, and no one will know when the right to counsel attaches. So I'd like you to respond to that. I mean, the defense of the bright line is that it's clear and everybody understands it. Why should we depart from a bright line test to get in what critics would say would be, undefined area of attaching the right to counsel?
I think we just have to reestablish where the bright line is drawn. And in doing that, we need to look at the underlying purpose of the right to counsel, which is what a lot of states do when they interpret their own state constitutions when deciding whether right to counsel attaches pre-indictment or pre-filing. I think the Friedman case offered us a footnote that included several cases that departed from that federal standard that an indictment must be filed or a formal charge must be filed. There are at least two cases or two states that have departed from the holding in Moran versus Burbine. And in their state constitution, they have interpreted the right to counsel to include the right for a defendant to be advised that his or her lawyer is attempting to contact them while they're in custody prior to arrest. There's a couple of states that have also...
But was your client arrested?
He was placed under arrest.
Okay. All right.
That, I believe, is undisputed. The request and notice form that's included in the record under the minutes of testimony indicates that, along with reasonable grounds, the reason for invoking implied consent included that he was placed under arrest pursuant to Iowa Code Chapter 321J.
What would be your...
Counsel, would you agree that the officer complied with 80420?
In the general Craney sense, I believe that the officer did comply with 80420.
You're asking us to strike down as unconstitutional the provision in 80420 that says that the phone call shall be in the presence of the officer.
It depends on the application or the interpretation of 80420. If you look at Craney, which states the purpose of 80420 is to enable a person to arrange for a legal consultation and assistance. That part, I believe, was satisfied. However, in the specific context of an OWI, where we assert a case does exist, and this is a critical stage in the proceeding, there is a constitutional right to a private telephonic consultation that certainly supersedes Section 80420. Now, as applied, there may be an argument that it would be unconstitutional. Certainly, facially, I don't think I could make that claim because there are any number of cases outside of the OWI context where 80420 would be satisfied by simply advising the person of their rights under the statute.
We have to interpret, do we have to get to the constitutional issue if we would interpret presence to mean something else than standing over and listening?
Well, again, if you did that, you would be readdressing the language of Craney, which states what the purpose is, which is merely to arrange consultation and assistance.
Sure, but I think what Justice Wiggins might be suggesting, and I'm sorry to speak for him, but
That's okay.
But presence and listening is not necessarily the same thing. I mean, everybody's present in the courtroom, but if I lean over and talk to Justice Wiggins, they probably aren't listening. Is there, maybe that's too much gymnastics, I don't know, but the statute on its face at least requires presence. Would it be possible to interpret the statute constitutionally from your perspective if presence meant I'm watching you on the phone, but I'm not listening?
Well, ultimately, when we're talking about a situation that's pre-charge, pre-indictment, when a right to counsel is appropriate, such as a Miranda situation, the officer is required to advise that person of their Miranda rights, which would include their right to counsel. I believe, under Article 1, Section 10, that Mr. Senn had a constitutional right to a private consultation, and with that...
Couldn't he have it? I mean, you know, today's technology, they have all kinds of video cameras and all types of way to observe the person. So technically he's in its presence, but as long as they don't listen into the conversation, he can say anything he wants over the phone, unless they're taping the phone, which we've dealt with already.
Yeah. My answer to that is, again, with his constitutional protections, I would submit comes an advisory that should come from law enforcement. As the state of the law is under Section 804.20, law enforcement is not required to advise a motorist of their 804.20 rights unless some comment or statement comes from the motorist coming close to invoking those rights.
Well, the U.S. Constitution recognizes a right to counsel prior to arrest and a custodial interrogation. I mean, are you equating this to a custodial interrogation under Miranda where, you know, or answering the question, is that an interrogation? I mean, that's sort of troublesome to me. And at one point, I'm going to ask your opponent about that a little later.
Well, insofar as it's a critical stage of the proceeding, it would be analogous.
Well,
Miranda's a Fifth Amendment case, not a Sixth Amendment case,
It
right?
is, but it includes the advice that he has a right to counsel, and that's what I'm arguing is that if under the Iowa Constitution, in a limited context of an OWI, when implied consent is invoked, a motorist needs to be advised that they have the right to speak telephonically and perhaps privately with a lawyer about the consequences for refusing.
But factually, in this case, didn't the officer in fact do that? He said that as long as your attorney comes down here, you can have this private consultation with your attorney. And so even, you know, Friedman recommended or said that this was a limited right. It was a limited right to do this, which to me the statute seems to provide you with that limited ability to consult with an attorney. And then he did actually, or correct me if I'm wrong, but the officer in this case did in fact then advise him that, well, no, you can't do it over the phone, but if he comes down, or he or she comes down, you can have this private consultation.
Yes, under 804.20, that's the current reading of the statute. However, I argue that it's in contradiction to his constitutional rights, which would allow him to have a telephone conversation privately at that time. It's very difficult for an OWI attorney to have a conversation with a client. In this case, I would assume that the attorney-client privilege attached. When an officer is sitting in the room, if you watch the video far enough, unfortunately, Mr. Senn made some very incriminating statements about his level of intoxication. And privilege is waived when there is a third party privy to the conversation. So,
Was there another third party in the room?
there was.
Who was she?
I don't believe it's in the record, but I've anecdotally obtained some information that it was a ride-along with the officer and nobody associated with Mr. Senn. So presumably, if the officer would have recognized and appreciated my client's request for confidential communication, that party would have left the room as well.
And getting back to this issue about what presence means in 804.20, is it fair to say that's not an argument you're raising on appeal? You're just raising a state constitutional argument?
We're raising it as a state constitutional argument.
Okay, thanks.
of course, we try and construe statutes to meet a constitutional objection, right?
That's the state of the law, correct.
If we recognize a state constitutional right to counsel at this point, wouldn't the state have to provide a free lawyer to any indigent person in that situation?
That is actually an issue that was raised, I believe, in the Spencer case out of Oregon. And I'm trying to impress upon the court that this is a limited constitutional right, and we appreciate that a time-sensitive decision needs to be made. And for example, if for no reasons that can be attributed negatively to the motorist or the officer, if they arrive at the station and they're approaching that 15-minute observation period, that could truncate or eliminate the ability to speak to counsel. So I think if you fashion it in a limited, specific context, that it does not implicate the Equal Protection Clause or Gideon, which is what the Oregon Supreme Court ultimately concluded.
Do I understand correctly, in Minnesota, you don't get a private phone call, but the remedy under the state constitution is that the state cannot use any of your admissions that they overhear?
I believe, yeah, Friedman, I believe, was maybe superseded by statute, and that could be the remedy. But we're advocating more of an approach that Oregon has taken, which is giving them a private consultation, and the remedy would be exclusion of any evidence, including the test refusal.
What about the state's need to monitor calls at the initial arrest? For example, these apply, I mean, the statute applies across the board to any arrest. What if the arrestee is on the phone saying, hey, get rid of the body, or some other, something like that?
Hopefully that won't come up in the context of an OWI, but sure. I do appreciate the question, and I think it's something that needs to be addressed, because often as lawyers we see officers citing to safety concerns for not allowing somebody to be alone with a cell phone or a telephone. But I've read cases, and I'm not sure if it's out of Oregon. They all become a swirl after you prepare for your oral argument. But what I would propose is that it's a reasonableness standard. And if the state feels there's some need to interfere with the limited right, then they would need to establish that it was reasonable under those circumstances. For example, if the person has been aggressive and belligerent, or if the monitoring time is closing in, and those are the reasons the state cites to, then they could be potentially valid reasons. And those reasons, by the way, have largely been addressed by this court in the context of Section 804.20. So we do have a bright line rule to guide us on how we can communicate with our clients privately. I see my time is up. Thank you.
Thank you as well, Mr. Brown. Mr. Sloven.
Thank you, Mr. Chief Justice. May it please the court. Counsel. Good morning. I want to start by addressing some of the questions that were raised about the scope of this challenge. Justice Waterman, you asked, did the officer comply with 804.20? I think it's agreed that he did, that this is a challenge just to the language in 804.20, the requirement of the officer's presence, that the only challenge is that that requirement itself is unconstitutional under Article 1, Section 10 of the Iowa Constitution.
What do you make of the suggestion that presence doesn't necessarily mean overhearing the conversation?
So,
the statute does, the statute says in the officer's presence for a phone call. But Justice Wiggins was working on a possible distinction, and I'd like your answer.
Sure. So my first response was that that wasn't raised below or briefed on appeal. My next response is that I agree that this court will read a statute to save it from any constitutional infirmity. I think that arriving at that reading is dependent on finding a constitutional infirmity to begin with. So it's the state's position that there is no infirmity, that there's no right to counsel that attaches at this phase, either under the criminal prosecution's language or under the cases involving life or liberty language, and there's no reason to reach the issue of what exactly presence is.
What's the point of having a requirement that the phone call be in the presence of the officer unless the officer's entitled to listen in?
I think that's a good point, and I also would point out that the statute doesn't say the officer shall observe. It says the officer shall be present. Now, unless we're talking about, and present, I think the common meaning would be physically present. Unless we're talking about a workaround that involves earplugs, I don't think there's any way for the officer not to listen in. And I think that the legislature, insofar as if it doesn't violate the Iowa Constitution, the legislature's entitled to make a policy judgment that the officer should listen in on that call. And I think the reason for that outside of the OWI context was touched upon is that we want to make sure that someone brought in as a suspect in a criminal investigation can't just assert a right to a confidential phone call with an attorney, then when they're alone in the room, call an accomplice and instruct them to dispose of evidence or take other action to evade the impending investigation. In the OWI context,
Let's get to the guts of the case, at least as I see it, and that is that the evolving federal case law, at least, as I read it, is very formalistic. It basically says, well, the commencement of the criminal proceeding is a filing of a piece of paper, if you will. But there's federal case law, and I'm thinking of even Kirby itself. Kirby was a plurality opinion, as you know, but there was talk about adversary, the beginning of the adversary judicial criminal proceeding should not be a mere formalism. And Justice Stewart and Escobedo talked about making sure that the initiation of a prosecution is not overly formal. In the United States v. Wade, there's authority out there that says, look, there's a desire for a bright line test, but there's a countervailing feature that says, listen, we shouldn't be overly formalistic in it. That gives rise to looking at the actual context and whether the state is leaning on somebody where the right to counsel would be helpful. And I think the defense argument is, well, listen, in the context we have in this case, it's a critical stage of the proceeding, of course. I mean, there's a key decision being made. And if you decide not to give the implied consent, the trial means nothing because the case is already made. You understand, I think, where I'm struggling.
Sure, and I think that there's a lot to unpack there. The first thing that I would say is that even if this is a critical stage, if it precedes the initiation of the criminal prosecution, then the right doesn't attach. I think the language from Arroyo is really important on this point, that the right clearly says it's limited in its scope to in all criminal prosecutions. It vests in the accused. If we divorce the right from that language, then suddenly we have this floating ethereal right that really has no basis in the text of the Constitution.
Both Pennsylvania and Mississippi, for example, say it's at the time of arrest, and they have constitutional language very similar. That of course brings the attachment of the constitutional right well back and would cover it here. The language is what it is, and that's what we're kind of fighting about. But
sure, I'd point out in Pennsylvania that even with that interpretation that they've reached, that doesn't extend to, they hew pretty closely to the federal interpretation of when the prosecution begins, and then they also, in Commonwealth versus McCoy, said that the implied consent or the analogous decision is not one where the arrestee is entitled to counsel.
I guess frankly, I see more play in the language maybe than you do. But what I'd really like, if you would, I do see some merit in the bright line rule, quite frankly. Bright line rules are, easier to administer, et cetera, and that's, I think, the strength of your case. On the other hand, the whole purpose of counsel is to be available, as I say, when the state is focusing on you and is seeking to establish and inflict punishment. And that's a perfectly legitimate process. I'm not criticizing the state for doing it. That's what they're supposed to do. But the right to counsel, if it means anything, has got to attach at critical times. And don't you think here that if you don't get counsel when you're asked to give the implied consent advisory, counsel down the end of the line is almost worthless? Do I overstate?
I would disagree with that,
yeah,
actually.
Okay.
So
come at me.
So when we talk about what's a critical stage, and again, the defendant, the citation to Wade, and in the brief doesn't propose an independent standard, so we apply the federal standard for what a critical stage is.
No, wait, he's got an independent standard.
Well, not for what a critical stage is, right? It's still the same Wade analysis of whether counsel's absence will seriously derogate from the fairness of the resultant trial down the road. And I think that this is where I take issue with your analysis of the case, is that counsel's absence what he's asking for is a confidential phone call, not even the physical presence of counsel. Usually when we find a critical stage, what we're saying is that unless counsel is physically present for that confrontation between the state and the individual, there's no way to guarantee a fair trial. Even without the confidential phone call, This isn't a critical stage because the data, I mean, if there's a refusal, we know that he refused, we have his signature or his refusal to sign. If there's a test result, we have the data master results that show the calibration, that show what he actually, the actual blood alcohol content that he blew. So it's not something that can't be reconstructed at trial. It's not something that seriously undermines the fairness of the proceeding. I would compare this to the handwriting exemplars that the U.S. Supreme Court said were not a critical stage requiring the presence of counsel in Gilbert versus California, because even though it's good evidence that the state obviously wants, it's not something that can't be reconstructed at trial. It's not something that can't be cross-examined, like, for example, a post-indictment lineup or a post-indictment interrogation. Right? The problem.
And why isn't this an interrogation? A question is asked, at least, I gather, right?
Sure, and I think that I think that we've already established in other cases that this is not an interrogation when we ask for the implied consent decision. That there's some element of trying to investigate.
Doesn't the McNeely case change all that? You know, where the U.S. Supreme Court went after and talked about the implied consent laws, and you are asking someone to do something, and if you look at Miranda, which I think is based on the Fifth and Sixth Amendment, they have components of both the Fifth and Sixth Amendment, right to counsel. I mean, don't you get crosshaired in there after McNeely? Because McNeely talks about, the OWI cases about, you know, you have to get a consent, you have to get something from the lawyer, from the driver before you can take the blood test.
Right. I think the answer to your question is contained in that last sentence that you said, is that what McNeely said is that you have to get consent to get the sample, that it said that the dissipation of alcohol in the bloodstream is not a per se exigency justifying the draw of the sample over the refusal, that presenting the question, will you give us a sample, that's not impermissible under McNeely. Taking the sample after they refuse as a warrantless search.
But then you get the self-incrimination and the right to counsel components of Miranda in there. That before you're going to give yourself up, you have a right to consult an attorney. And that's what Miranda is. It's a Fifth and Sixth Amendment case. And now after McNeely, at least in the drunk driving area, I don't know if we can go beyond that. But in the drunk driving area, you have, he's in custody, he's arrested. He is interrogated, asking to give up a right, and you're going to say under McNeely, yeah, you have to get the consent, but you don't have a right to talk to a counsel before you self-incriminate yourself.
So I disagree with that characterization that he's being interrogated and asked to give up a right. What he's being asked to do is provide the sample. He's already impliedly consented to giving the sample. He's being asked to reaffirm that consent or to refuse.
We're not sure.
We're
not sure that's even constitutional after McNeely. I mean, the U.S. Supreme Court has that case.
Well, in any event, it's not raised in this case. I made sure to reread McNeely before coming here this morning, and I still think that McNeely doesn't invalidate Iowa's implied consent laws. This is, again, not a case about drawing a sample after a refusal. It's not a case where the state attempted to invoke the per se exigency involved with alcohol dissipating into the bloodstream. So if I could move on to I just want to point out some of the implications of what the defendant is asking for here. Now, there's a lot of reliance on Friedman out of the Minnesota Supreme Court. Friedman eradicated the Minnesota bright line for when the right to counsel attaches. And I want to draw the court's attention to Stoskopf, a Minnesota Court of Appeals case that cites Friedman, that talks about the issue. It analyzes a challenge to the preliminary breath test, the PBT at the side of the road. And the challenge there was, does the defendant have a right to counsel under the Minnesota Constitution when he's asked to provide that PBT? Now, you can see how that bears a lot of similarities to this challenge, right? He's being asked to give evidence that could be very critical against him, actually, since he had a special license that prohibited any alcohol. That would have been presumptive proof of his guilt, right? And that's at a roadside confrontation with the police when it's still, like the implied consent proceeding, still in the investigative phase. And the Minnesota Court of Appeals rejected that challenge, but it's really not clear to me, looking at that reasoning, what allows them to do that after Friedman. That if you extend the concept of a critical stage to where the
Minnesota law, similar to Iowa, is the PBT admissible in Minnesota? Not in Iowa, I don't think.
I think that's correct. I don't
is
know
it-
for sure if it is in Minnesota.
So wouldn't that be, wouldn't the distinction you should have figured out before you make the argument?
But I think that the idea is that it would have given the officer presumptive evidence of his intoxication to that would influence his testimony. It would have been critical evidence in the investigation that would have generally guaranteed that the officer would continue investigating.
My understanding of the PBT is another reason why the officer may believe someone is intoxicated
Sure.
to lead to the test. But the PBTs aren't admissible in Iowa, and I don't know
That's
about
right.
Minnesota.
And what the reason I brought up this case is to just illustrate where the extension goes. That if the test for what a critical stage is the state going to gather evidence that could be presumptive evidence of guilt or admissible in a criminal trial, then that goes even as far as the first question at the roadside stop. Sir, have you been drinking?
Well, how about if you narrowed it up a little bit? And I do understand your point, that there's investigative features that the right to counsel doesn't attach every time an officer or law enforcement agents engage in some aspect of investigation, and I see the power in that. But on the other hand, here we have an arrest, and then we have the question, whether it's interrogation or not, I'll set aside, but the question about implied consent. It's focused directly on him. So we have an arrest and a critical stage, and where the right to counsel, arguably at least, would be very important. So doesn't that cabin the position of the defendant here? I mean, it's not running loose in all kinds of investigations.
I mean, I don't think so, Your Honor. I look at the definition of case that's provided in the reply brief. I really think that, and really just the definition of critical stage that's attempting to go beyond the point of attachment, the point where a criminal prosecution begins. And this court has repeatedly said that it likes bright line rules, especially in this context, when we're talking about time-sensitive interactions between police and citizens, when we're talking about, we want to make it clear to law enforcement what exactly their responsibilities are.
He would say there's all kinds of bright lines. The question is where to draw a bright line. I mean, he would suggest, I think, that there's a bright line when you arrest somebody for drunk driving and you request implied consent, or you give the advised consent advisory and request consent. Bright line rule, right to counsel attaches.
So I'd direct you to McCambridge, the Texas case, where discussing Texas's experience with adopting the Oregon Supreme Court's reasoning in Spencer, and then finding that it was vague, unworkable, ambiguous, and then deciding to go back to the federal bright line standard for when a criminal prosecution begins. I think that's instructive. I don't think that's a...
The bright line rule, it's just the plain language of our state constitution referring to criminal prosecutions or cases, which implies there's something filed in court. If you look at the 7 rights provided here, a public trial, an impartial jury, a right to confront witnesses, the subpoena power, all of those make sense only in the context of a pending case in court, right?
I think that's correct. My time's expired. Thank you. I think that's correct, and I think that's really important to remember. Not only, like you say, that it's a criminal prosecution that triggers all of these rights, but that they only vest in the accused, the person who is confronted with the accusatorial power of the state, not the investigative power, but the accusing power within that adversarial framework. So I think that the plain language of the Constitution, regardless of what we think about 80420 as a policy choice, I think we need to recognize that the Iowa Constitution does not make that unconstitutional. Thank you.
Mr. Sloven, thank you as well. Mr. Brown, you may present your rebuttal.
Thank you, Your Honor. I'd like to pick up where the state left off when we're talking about the investigative stage and the accusatory stage. Admittedly, there is an investigative stage in this case, and it takes place out in the field when the officer has a suspicion that Mr. Senn is operating while intoxicated. There is the telltale signs we see in every single case, which includes red, bloodshot, watery eyes, slurred speech, and an odor of alcohol. We also have performances of field sobriety tests that start to develop the case the officer is creating against Mr. Senn. Then there is the preliminary breath test. Mr. Senn does have the right to refuse that or to submit to it, and if he fails, he could be placed and will be placed under arrest, which happened in this situation. My argument to you is, at that point, the accusatory phase ends. There is no more general inquiry at that point. There is a specific focus on Mr. Senn, and in fact, Your Honor, there is a case, and if you look in the minutes of testimony, there are 2 documents that are presented to Mr. Senn at the time that present case numbers. They have case numbers on them, which signals that this has changed from a general investigation into a case of an accused.
What would have happened to your client if, when he got on the data master, it came back .04? He would have been released, right?
Not necessarily, because the law does allow prosecution of individuals whom they believe are operating while impaired, which could include, problems with motor skills and things like that. The .08 is presumptive intoxication, but it doesn't preclude or foreclose a formal prosecution on something less than .08.
What about the constitutional provision, Article 1, Section 10, begins with the notion of criminal prosecution. You heard the question, says, well, I mean, that starts with the filing of a piece of paper at the courthouse, and of course, at whatever in the morning it was, there was no piece of paper filed.
Agreed, but there are also a number of states that have interpreted their own state constitutions to extend beyond just the filing of a formal paper. I believe there was reference to hand exemplars in the federal realm. However, there is a state constitution or state court case that's cited in Friedman in a footnote where that state had extended the right to counsel for hand exemplar analysis.
Okay, so what does criminal prosecution mean to you?
Criminal prosecution, you have to go back, I think, to look at what the fundamental purpose is. And it's to protect a person who lacks the skill or the knowledge to protect themselves or defend themselves against the arm of the state. And my argument would be, which was quoted in Friedman from the Ash opinion, that expansion of these rights is necessary when a new context arises presenting the same dangers that gave the birth to the right in the first place. And that's what we have here. We have a new type of crime, OWI, that did not exist at the time when these amendments were being passed. We have the advent of cell phones where people call us generally without even the need for law enforcement phones. And what we're asking is, rather than have it in the presence of an officer, let us talk to him alone. Let us talk to her alone so that we can give adequate legal advice to them to make the ultimate decision on how their case could proceed once formal charges are issued.
Could you respond to the state's argument that this isn't a critical stage because the lawyer doesn't really make a difference?
Well, I guess I would respond that perhaps.
That way, but with your experience in OWI,
I don't mind if you phrase it that way.
how does a lawyer help on that decision whether you take the test or not?
Well, it's always case by case. We need to gather a lot of information. And just like the law says that alcohol quickly dissipates from the system, it can also quickly absorb into the system. And some things that I try to determine is my client on the other end of the phone, are they in absorption phase, or are they in elimination phase? In order for me to do that, I have to gather a lot of information about what did you have to drink, when did you drink your last drink, when did you eat, how much do you weigh, and it kind of gives us an idea as to, are they on the up or are they on the down? And if I'm required to go down to the station and they were still increasing their BAC, I provided a disservice because I should have told them earlier, perhaps you should have taken it an hour or two ago because your BAC would have been lower.
Do you do that effectively with the yes or no question?
Not really. It's difficult because you need to ask a lot of questions, and depending on what answers you're giving, you have a third-party law enforcement officer who's recording it and listening and gathering evidence that will be turned over to the state on those kinds of questions.
Can't you call an expert at trial to explain all of that based upon how you've discovered the evidence in your own investigation?
I can, but often the best time to gather the information is the then and there circumstances, and I still don't think that eliminates my client's right to counsel.
Other critical questions though a lawyer has to ask about whether there was an injury, whether there was a death?
Absolutely.
Because based on what happened at the scene, if you take the test, you're allowed to get a deferred judgment, but if you kill somebody or severely injure somebody, you can't get a deferred judgment, so why would you tell your client to take the test if it's going, I mean, there's all other things. There's all kinds of subtle things you want to talk about.
We could spend all morning talking about the things that we would want to discuss with our clients depending on the circumstances, and those are very critical questions that we would ask, and that are, again, are very hard to explore when you're in a yes or no format, knowing that an officer is sitting right there recording or writing down all of that information that's being supplied. I see my time is up. Thank you for your attention.
Mr. Brown, thank you very much. The case is now submitted, and we'll hear the arguments in the just matter.